Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Naomi Comfort, one of my favorite guests.
Oh, well, thank you.
Anyway, Naomi is an attorney. Her law firm is Silicon Valley Elder Law. Naomi has taught continuing education courses on fiduciary income taxation and other subjects to CPAs, attorneys, and the public. And Naomi and I have actually done seminars together, which has been fun, and she's been a guest several times on this show, so I'm really looking forward to our conversation today. Today, we're going to be talking about something newsworthy, so I'm going to mention the date. We're recording on July 22nd, 2014. This will be on the internet, so people may see it sometime later. We're going to be talking about Donald Sterling, who is currently, I guess, still the owner of the Los Angeles Clippers, in the process of having to disgorge the team. We'll be talking about that. Anyway, so we're going to be talking about how it relates to estate planning documents in action. And that means, again, we're going to be talking about, different legal concepts. And so this is a little superficial, I'll warn you. But what we're trying to do is stimulate your thinking so that you'll think, maybe I really should be going and talking to a lawyer about how this relates to me. So, Naomi, thank you for the suggestion, and thank you for being with me today.
Well, thank you. And I am not very starstruck. I don't spend a lot of time watching TV or movies or that type of thing. But I just felt like this was such an appropriate topic because it really shows you how estate planning documents that so many of our clients have, how they are implemented when somebody actually does start to lose capacity. And that's what we're going to be looking at today. We're not talking about this to gossip about Donald Sterling or to gossip about what might happen or to pontificate on that. We're going to look at how this might relate to your personal circumstances and estate planning documents in general.
Okay. Nonetheless, Naomi, first of all, because some people are going to be more familiar and some less familiar with this situation, so maybe you could just sort of summarize a little bit about, what happened in this case, because it is kind of an interesting story. We had, a successful basketball team owner somehow got involved with racial slurs, MVA ban and fine, now probate court and so forth. And most of us think, probate court just has to do with people who are deceased. But now we've got a situation with somebody who's living that's dealing with these issues. So maybe you can sort of get us into this a little bit.
Sure. So procedurally, what we've got going on is we've got an owner, Donald Sterling, who has gotten into some trouble with the NBA that issues the franchises for the teams. And because of these terrible things that he said, which were recorded by, I don't even know, his girlfriend, I think, that he has been fined some huge amount, and he's been banned from the league, and the NBA is taking steps to force him to sell the team, to basically confiscate the team from him and then auction it off. So Donald Sterling and his estranged wife, Shelley, legally, they own the equity in the team. But as part of their personal estate planning, they took their ownership interest and transferred it into their living trust. And a living trust is an estate planning document that many people in California use to hold title to their assets during their lifetime, to avoid probate when they pass away, because probate proceedings in California are just horrid. But also, what people don't focus so much on when they're doing their estate planning is another big purpose of these is to avoid conservatorship proceedings on incapacity. So these documents, they all have provisions in them that say, if the owner, if the trustee who is managing these assets becomes incapacitated, then they are removed as trustee. They still equitably own the assets, but they no longer manage them. Somebody else is going to be the trustee. So what happened here is we had the team ownership was placed into the trust. There are two levels of ownership. There's equitable ownership, which stays with Donald and Shelley.
Right.
There's the trusteeship, and the trustees are the ones who manage the assets. Initially, Donald and Shelley were co-trustees of the trust. When all this started happening, Shelley had two doctors evaluate Donald. Each of those doctors determined that he was unable to manage his affairs and could not continue to act as trustee. Apparently, the document, their living trust, says that in order for a trustee to be removed, somebody has to get two doctors' letters saying that the trustee is incapacitated. Once you have those doctors' letters, that incapacitated trustee is removed, and the remaining trustee, under the terms of their document, that's Shelley, can act alone. So what Shelley did was she got the doctor's letters, she had Donald removed, she engaged in this transaction to sell the team, and she signed a contract as the sole trustee of the trust.
Okay.
Now back to your question, how do we get into probate court? Nobody's dead. This is a contract, and they're disputing, Donald ultimately is disputing the validity of the contract.
Of the trust, huh?
No, of the contract that was signed, the sale contract.
The sale contract for the
He's
team.
trying to keep the team from being sold.
I see.
Right? He doesn't want to sell the team. So how he's attacking that contract is based on the fact that Shelley, in his opinion, did not effectively remove him as trustee, so therefore she could not be the sole signer on that contract.
I see.
So instead of being a civil action about the contract, it became a probate action because it's an interpretation of the trust instrument.
Okay.
And what the judge is looking at, and this is a really interesting piece, the judge is not evaluating, is Donald Sterling incapacitated or does he have capacity? That is not what the judge is doing. This case is all about the question of whether Shelley followed the provisions in the trust accurately and appropriately in removing Donald, and therefore was allowed and had the authority to sign that contract as the sole trustee. It is all procedural. It's about those two doctors' evaluations. It's not about Donald's current ranting and raving. If you've followed any of this in the news, apparently he's been pretty obnoxious, I will say, in the courtroom. But it's not about that. It's really about whether those doctors' letters that Shelley obtained were obtained properly and sufficient to remove Donald so that the contract can stand.
Yeah, but if you're trying to have a judge that's saying this doesn't seem, these doctors, maybe they don't know what they're talking about, but then you're acting in this way, then I think that you're not helping yourself.
This is true. It's very, it is somewhat convoluted because Shelley had these doctors' letters, right?
Yeah.
And Donald's attorneys are arguing that these are actually social friends of Shelley's and that she could control what they were saying and the conclusions that they were reaching. And therefore they weren't independent or somehow they weren't sufficient, that basically they were biased in favor of Shelley. And so they weren't true independent evaluations. Subsequent, from a timeline perspective, Shelley got the doctor's orders, she signed the contract of sale, then Donald revoked the trust. He, as the settlor, signed a document saying, I revoke the trust with respect to my interest in the trust.
Oh boy.
And what's really interesting is both sides, Donald's side attorneys, of course, and Shelley and her attorneys, all the parties agree that he had the capacity to revoke his interest in the trust.
Okay.
So that the capacity to say, I'm taking my assets out of this trust is much lower than the capacity to be able to manage this extremely, I'll say, volatile as far as the valuation of this asset, because it is a volatile situation right now as far as what the value of the team, the Clippers, might be.
Yeah.
Right from the moment that these recordings of these racial slurs became public, all the sponsors, everybody started pulling their support of the team. The players themselves are threatening to strike.
Oh, dear.
Managers and other people are just bolting left and right. And so you're left with the situation of it, you know, the value of the team is potentially going down. He's got all these related financial obligations that go with owning the team, and he's
Right.
not got the resources coming in. You've got the threat of the NBA actually pulling ownership and then auctioning the team off, which may result in a much lower financial get for the Sterling. So for him to have the capacity to negotiate those sales and handle these sophisticated assets is a much lower level of capacity than to just revoke the trust. But it adds an interesting twist that he has diminished capacity, so he can't manage the trust, but he had enough capacity to sign saying, after this took place, I revoke the trust. It doesn't undo what happened before, so his revoking the trust doesn't undo the contract that Shelley signed, because you have to go in order of time of how these things happened.
Okay.
It's a very complicated situation in that respect.
Yeah, so it brings up a number of issues. I guess we'll try to work through sort of in your train of thought here a little bit, and before I go around Robin Hood's barn here. So he actually had a diagnosis of Alzheimer's disease, is that right?
You know, I honestly don't know what the standing diagnosis is. I think that the doctors have found that he has dementia or cognitive impairment or memory loss of some sort, but I don't know what the label is that they've put on it.
Okay.
One of the issues that comes up with that, both here and in my practice, is, well, if he's got Alzheimer's or if he's got dementia, then clearly he doesn't have capacity to manage his affairs, correct?
Well, I mean, you have different stages of Alzheimer's,
Right,
of course, so
exactly.
it's a debilitating disease. So initially, you may have some capacity, and then eventually. But it does remind me, I mean, of course, we dealt with this a little bit. If you folks have watched before, I've talked about my experience with my father-in-law. And we were very fortunate in his case, like the doctor said, well, now that you've been diagnosed with Alzheimer's, of course, that means you have to give up the keys to the car. And he said, okay. And so we were very fortunate that he wasn't in this argumentative frame of mind.
Right.
And so he actually made it much easier for us. But when you have a person that's in an argumentative frame of mind, now, well, one, of course, you have a situation that's set up for litigation because any lawyer will be glad to represent him.
When you've got billions of dollars, it's pretty easy to find an attorney, yes.
And so, but on the other, I mean, the first thing that comes to my mind before maybe we get into some of this, and I'm afraid of, I apologize a little bit if I get you a little off track, but it seems to me that then somebody could move or try to have him conserved, isn't that right?
Exactly. So when we're dealing with these cognitive ailments that start in people's final years, it's a slippery slope. You might be fortunate to get a diagnosis early enough in your impairment that you're still able to do things. But what we see is there's a time for diagnosis, and then the initial phase of the illness is the time when the elders are the most vulnerable, because they're starting to they still have capacity to make decisions, but they're not necessarily making good decisions because their cognition is impaired. So they're not thinking things through clearly. Or, for example, with Donald Sterling, their filters, their social filters that they have had in place that have helped them maintain an appropriate place in society, those are gone. So maybe things that he was thinking before or that were kind of hidden that he knew he shouldn't say, now they just come out. And they cause all sorts of problems, both interpersonal problems and legal problems. And it can really result in financial risk for people. I mean, here you see it with Donald Sterling, huge financial repercussions to what happened with his statements. So there is a period, though, from diagnosis to the point where you actually lose sufficient capacity that we would find somebody legally incapacitated and unable to manage their financial affairs. And it's going to be a different standard for different purposes. For example, like I was talking about with the trust in this case, he does not, according to the doctors, have the capacity to continue to manage these huge assets, but he does have the capacity to say, this trust is not what I want, and I'm revoking it.
Yeah, but now by taking it out of the trust, he's set up the situation again that we were trying to avoid by setting up the trust. Because now we may have to have a conservatorship because we're not going to have the mechanics for managing.
But we don't know what he's done with following up with revoking the trust. For example, if this was a client of mine, not that Donald Sterling of bazillion dollars is going to come see little Naomi Comfort here in San Jose, but somebody like in his situation, he has significant complex assets.
Yeah.
He and his wife are estranged.
Right.
Right? This is not a functional, happy marriage. They are estranged.
Right.
But they co-own these significant assets together, and as under the trust, they're co-managing them, except now she's removed him, so she's managing all this stuff on her own. This is his estranged wife.
Right.
If he had come to see, if this was a client who'd come to see me, who had assets in a trust with a spouse that they are estranged from, I would have had him revoke the trust and set up a new trust, right? So the immediate thing is the old trust joint with Shelley is revoked. All my assets get poured into my new trust that's not joint with Shelley, and that instead of Shelley being trustee, my attorneys advise me I should also not be trustee, so I'm going to name this professional person or this bank or this corporation to be my trustee, but not my estranged wife.
Yeah.
So if his attorneys are advising him with respect to his ongoing estate planning needs, that would be the steps that they would have taken. They wouldn't leave his assets just hanging there.
Yeah.
But he's got litigation attorneys that are working with him, so I don't know if they're focused on that. But one of the things that's nice about this, what I call the slippery slope, is if you're in a situation where you or a family member has been recently diagnosed with dementia or another cognitive impairment, it is critical to, at that point, go and review your estate planning documents to make sure that they still work for you.
Right.
Because you can see there is a point in the near future where you're not going to have capacity to modify those documents. And Donald Sterling, fortunately for him from that perspective, everybody agrees he does have the capacity to revoke that trust and hopefully set up a new one for estate planning purposes. But that way you deal with things like the estranged wife, that you no longer want to have sole control over your assets and be making decisions for you because you're estranged. You're not on the same page anymore.
Right.
Now, California law will automatically remove provisions in favor of an ex-spouse. So if they were actually divorced, it wouldn't be such an issue because the assets through the dissolution would have been removed from the trust and split between the two of them. But even if they weren't, anything in favor of each other, they're treated as having predeceased each other. And so if you have a trust and you get divorced and you don't ever do anything about your trust or your assets and you die, your wife, your ex-wife that's named in that document is not going to get your estate. She'll be treated as having died before you, and it'll go to the next named beneficiaries. So there are code sections that deal with that specifically.
Yeah, yeah. Fascinating. I mean, so many implications and so forth. Some people, if they saw something like this, and like you said, I mean, at least for a time, the wife had control of the assets as the surviving trustee with capacity. They may think, well, maybe I shouldn't even have a revocable trust. You know, is that really such a good idea? So, what do you think of What would you respond to something like that?
I can absolutely see people thinking that. They're looking at this big, ugly mess that this very powerful, wealthy man has gotten himself into because of a trust that says that, you know, 2 doctors' letters and you're removed and somebody else can make decisions. I can definitely see people coming to that conclusion. But really, the important thing is that that trust is there to protect you, the owner, from court proceedings. I can't protect you from litigious people in your life, but it's to protect you or your estate from the cost and expense of these court proceedings. And what Donald Sterling didn't do is update his estate planning when he and his wife became estranged, which has led to his estranged wife being able to step in and take control. What I would advise my clients is that they stay on top of their estate planning documents. We can draft the documents to say anything you want. My default language in my trusts would say 1 doctor's letter is enough to find somebody lacks capacity to continue acting as trustee. And I have reasons for that. It's because it's very hard for the agent to run around and get these doctor's letters and get all this stuff done, or the successor trustee to do all this. It's really a lot of work. And in my practice, I have the types of people and families where you don't have a lot of people backstabbing and running around and doctor shopping to find somebody who's going to determine the owner to be incapacitated. So you sit down and you have the dialogue with your attorney about how you want these provisions to read. It could say 1 doctor, it could say 2 doctors have to certify. It could say 2 doctors and a family member have to certify. Or it could have specific things that have to happen before you're deemed incapacitated and removed as trustee. It could really say anything that's not illegal as far as the finding of incapacity. And I think that's the issue here is the mechanisms that set up in the Sterling's family trust and how it came to be that Shelley was the sole signer on that contract.
Yeah. Well, the thing is that it may not even be inappropriate what was there. It's just that she happened to be the successor trustee. They also, though, both of them made this decision,
Correct.
you know, to continue to be married.
Correct.
And so, so they sort of set up this situation, and I guess I can say it doesn't seem to be that unusual. There's a lot of people that seem to have these sort of relationships, and for whatever reason, they decide to continue to be married.
Right.
And so,
Right.
so there they are. They've set themselves up, and so you know this kind of thing can happen, and so you just need to give some thought. Is this really what I want?
Right.
And,
Right. So interestingly, despite all of the anger and the loud accusations coming from Donald's camp, if you look at what Shelley actually did and what she is alleging happened in her court filings and in the documents and in her statements to the media, because that's what we have the most access to, she's indicated that Donald knew all along. He was actually involved in the negotiations for the contract. He was actually involved in the process of her doing this. He knew that she'd removed him as trustee based on these doctor's letters, and he was all in favor of her taking these actions to move forward until after the contract was actually signed, and then he didn't want it all to happen, and he's trying to undo it.
Yeah.
So it's interesting, and when you see what she puts forth as to what she did, when she did it, how and why, it very much appears that she is acting in the best interest of the trust estate as a whole and to protect Donald. It does look like that. And so it may be that these estate planning documents actually are working the way they were intended to. She is solely responsible as the sole trustee. Not only does she enter into that contract, but she has an obligation to protect the assets for Donald and for herself, and to invest them in a way that is appropriate for their circumstances. So she has a lot of fiduciary obligations toward Donald, above and beyond the spousal obligations that a person would have.
Right, as a trustee, and you know, I mean, the situation again that he sort of created, unfortunately, by saying these racial slurs, which how it got out there, I mean, it's just kind of a sad situation, but here it is. So anyway, but he's created this situation, and so now it has to be dealt with. And you know, and the league
Correct. Yeah, I
has
agree.
said, I mean, this is what you have to do. So it seems to me, from what I can tell anyway, that what she's doing is appropriate. And if he had somebody else in as the trustee, they may very well be doing about the same thing.
Yeah.
Because they're
one
sort of
would
being
hope.
directed to. I mean, it's not like, you know, she just came up with this herself. It's that, you know, the league has said, you know, either you sell it or we're going to take it and sell it for you.
Right.
It's better to have control of the situation to some degree, I think. Okay.
I would agree.
Well, what do you think? What do you think might happen here?
What do I think might happen? Well, you know, I don't have full access to
Yeah.
what's been said in court. Most of the information I have is third hand. But it seems to me that as long as the court can find that Shelley has followed the terms of the trust and she has not acted in bad faith, there is not really a reason to undo the contract that was signed. I think Donald's team, his legal team, has a real uphill battle to be able to get those doctors' opinions thrown out, those letters thrown out as being inappropriate. Because again, we're not looking at were they right or were they wrong. We're looking at, did she follow the procedures of getting the correct documents in place, the correct steps to have Donald removed so that she could act alone as the sole trustee. And I from what I'm hearing, it looks like she very carefully dotted her I's and crossed her T's and made sure everything lined up so that she could get this sale taken care of and the contract in place.
Now, when we say her team, what we're talking about is her legal
Her
team.
legal team,
Yeah,
excuse me,
the
yes.
The team that's
The legal team.
The team that's
Right,
representing
not the
these
Clippers.
people.
Right. Right.
So, I mean, this person, frankly, the Clippers is probably a small part of this guy's estate. So
it is, and in fact,
yeah.
that's another interesting piece to
Yeah.
Donald's argument that these doctors' letters are inappropriate, is because he has all these other businesses that he purportedly continues to manage and run.
Okay. Well, Naomi, I think we're about out of time. Juan has given me a little signal from the door. I guess his usual warnings to me for the time weren't working. But anyway, I want to thank you so much for being a guest and talking a little bit about this fascinating case.
Well, thank you.
Okay. Folks, we'll see you next time on Financial Insider Weekly.